Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Amsyar bin ARZU with matric number 2310155, and together with me AFIF Hakim bin AZHAR as my partner, and we will be presenting our presentation. We are from the group Bar Bench from tutorial Monday 3 to 4 p.m. So to begin with, Article 18 of the Universal Declaration of Human Rights, AZHAR, established the right to freedom of thought, conscience and religion, including the freedom to change one's religion or belief without interference. And Article 80 Clause 2 emphasized that this freedom is not absolute in the sense that no individual should be subjected to coercion and that impairs their freedom or to have adopt a belief of their choice. And nonetheless, Article 18 Clause 3 introduced the notion that manifestation of these freedoms may be limited, but only through laws that are necessary to protect public safety in order, health or moral. And in Malaysia, freedom of religion is one of the fundamental liberties enriched in Article 11 of the Federal Constitution, and this provision guarantees every individual to the right of profess, practice and subject to certain limitations to propagate their religion.
Article 11 of the Federal Constitution has give rights to every person in Malaysia to profess, practice and propagate their religion. However, there is still a restriction on the rights that may be practiced on the freedom of religion in this federation.
To begin with, right to profess religion, the term profess refers to the internal belief system and the public acknowledgement of one's faith. And this right applies to all persons in Malaysia, citizens and non-citizens alike, regardless of their background, as long as they are within the country. However, this freedom is generally protected. Certain limitations may apply, especially in relation to Muslims, due to other constitutional provisions and state laws according to the propagation or renunciation of Islam. In the case of Tiong Eng Huat against Kadi Basimas, where the court had the right to profess a religion in the case of minor is not absolute or independently exercisable by the child. Instead, it is a right that must be exercised through a lawful guardian until and unless the child has reached the age of majority, in line with Article 12 Clause 4 of the Federal Constitution. The second right under Article 11, it provides the right to practice religion. The term practice refers to the outward and active expression of one's faith. While this right generally protected, it is also subject to certain limitations in specific circumstances. For example, public order, health or morality may justify restrictions. And in the case of Muslims, state laws may regulate aspects of religious practice in accordance with Islamic principles. And nonetheless, the Constitution may strongly uphold the individual's freedom to practice their religion, reflecting the Malaysia's commitment to religious diversity and harmony. In the case of Mio Atikur Rahman bin Ishaq and others against Fatimah Sihi, where the Federal Court held that there are several factors important considering whether a particular law or regulation is constitutional or not under Article 11 Clause 1. First, there must be a religion. Second, there must be a practice. And third, that practice is a practice of that religion. And all this having proof, the court will then consider the importance of the practice in relation to that religion.
The third right that has been given through Article 11 of the Federal Constitution is the right to propagate the religion. Article 11, Clause 1 also guarantees the right to propagate one's religion. However, this right is not absolute. This right is still subjected to Article 11, Clause 4 that provide the restriction on exercising these rights. In the case of Titular Roman Catholic Archbishop of Kuala Lumpur against Menteri Dalam Negeri and others, the court upheld the ban and cited potential confusions among Muslims and the need to maintain public order and religious harmony. The decision reinforced Islam's position as the religion of the Federation and affirmed the state's authority to limit religious propagation to Muslims. As I mentioned before, in Article 11, there is still a restriction to the right of freedom of religion in this federation. Article 11, Clause 4 has set the restriction. Firstly, the right to propagate the religion is not an absolute right. Why? Because Article 11 Clause 4 mentioned that it permits state legislative assembly and federal government in respect of federal territories to pass a law restricting propagation of any religious doctrines or beliefs among Muslims. However, these restrictions is only applied to Muslims. Non-Muslims are not prohibited from propagating their religion to another non-Muslims, but they are restricted from propagating their own religion among Muslims. This also includes deviant teaching of Islam, as it can be interpreted under the terms of religious doctrine or belief.
Alright, in relation to Basirah case, first of all, Article 11 must be read harmoniously with the state level laws. Because why? While Article 11 guarantees the right to profess, to practice and to propagate the religion, but this right is not absolute, particularly in the context of Islamic teachings and practices. Second, according to the Administration of the Religion of Islamic State of Selangor Enactment 2003, in the section 119, where teaching Islam or matters related to Islam without authorization. So in this section, it says that no person shall teach or preach any matter relating to Islam without a tauliah issued by a Majlis Agama Islam Selangor. And similar laws exist in other states such as the Federal Territories and for Kuala Lumpur and the Kelantan Syariah Criminal Code Enactment, in which they provide teaching without a tauliah is considered as an offence and can lead to a prosecution under the Syariah law. Besides, Basirah case is also similar to the case of Fatul Bari Mat Cahya against others against Majlis Agama Islam Negeri Sembilan, where the petitioner challenged the constitutionality of Section 53 of the Syariah Criminal Enactment, which criminalised teaching Islam without a tawliyah, which is the teaching permit from the state religious authority. So, in this case, the federal court held that the phrase precepts of Islam includes matters of akidah, belief, syariah, law and akhlak morality, all of which are derived from the Quran and the Sunnah. And the court in this case ruled that the tauliah requirement was a valid regulatory mechanism to ensure Islamic teachings are in line with these precepts, thus the law was within the state legislature's constitutional powers.
To apply all the rules mentioned in this present case, Barisah has the right as guaranteed in Article 11 Clause 1, which is to profess, practice and propagate their religion. However, his rights is subjected to restriction as I mentioned before, and he must acknowledge the restriction in Article 11 Clause 4 and must follow the law passed by the relevant authority. Thirdly, Barisah is also subject to legal consequence under Shariah law, since deviant teaching of Islam is also included in the meaning of religious doctrine or belief. Therefore, Barisah has the rights to profess, practice and propagate his religion. However, he must comply to any law passed by the State Legislative Assembly as mentioned in the restriction in Article 11 Clause 4 of the Federal Constitution. To conclude, Article 11 Clause 1 of the Federal Constitution guarantees the right to religious freedom, including the right to propagate religion. However, this right is not absolute. Article 11 Clause 4 allows the federal and state governments to restrict the propagation of non-Islamic religions to Muslims. State laws, like the requirement of a tawliyah for Islamic preaching, are valid and to ensure that the teachings stay within the accepted religious framework. Overall, Malaysia's constitutional setup strikes a balance between individual religious rights and the state's responsibility to maintain public order and protect the special status of Islam.